Thank you so much for coming. I'm delighted to welcome you to our 2013 Public Service Awards dinner. We're always so happy to bring examples of successful lawyers dedicated to service and advancing justice to our community, but tonight's award recipients and presenters are truly exceptional. In the true spirit of the Levin Center that was founded by John and Terry Levin, tonight we honor work in the public service that takes place across a spectrum of law jobs and locations. The classic impact shop of the ACLU, the important pro bono arm of the law firm, and the law school clinic led by a fierce practitioner educator with and teaching student advocates. To start the evening, I do want to recognize John and Terry Levin, whose generosity has allowed us to hold this event every year and allowed us to fund the Levin Center for Public Service and Public Interest Law at the law school. John and Terry, thank you so much. I also want to acknowledge and thank the staff of the Levin Center for all they did to organize this wonderful event. Primarily Anna Wang, of course, Nagar Kadarai, Mark Gonzalez, Betsy de la Vega, and Titi Liu. Thank you to all of you. And I am extremely honored to welcome a very, very special guest, Chief Justice Tani Kantil Sakaue, who, as the highest officer of our courts in California, has served as a tremendous role model to so many of us, but really also as a fierce supporter of the legal services and access to justice communities since you started. We look forward to finding ways to partner with you through the Levin Center and the rest of the law school in increasing access to the courts for low-income, pro-per, and limited English-speaking clients in California. And thank you so much for honoring us with your presence. I also just want to say a quick and heartfelt hello to two recent recipients of the Rubin Alumni Award, Corinne Kendrick, who is now at the Prison Law Office, and David Sapp, who just got this award last year, who's with the ACLU of Southern California. Thanks for joining us tonight. But of course, my most special welcomes are for Roberta Kaplan, our very own Pamela Karlan, Jenny Chang Newell, her family, her supporters, her nominators, and her wonderful colleagues from the ACLU. Congratulations to our honorees. We are very, very touched and honored that you could be here. At the core of the Levin Center mission is really to help every student gain experience and better understand what it is about the system of law that makes our profession unique in its ability to help people, to change society, to make a better world. And tonight we celebrate the work of Jenny, of Roberta, of Pam, who have exemplified just that through their work and careers. This past Saturday, I, along with quite a few of the people who are in this room actually, was honored to have heard an address by Justice Edwin Cameron of the Constitutional Court of South Africa. He spoke at the Ford Foundation Symposium on Public Interest Law to an audience comprised primarily of second and third year law students. Those of you who are in the room will remember him. And Justice Cameron shared details both of his personal as well as his professional life and described the simultaneously inspiring and troubling arc of law reform and constitutionalism in a post-apartheid South Africa. And in response to one student's question about the gap between the promise of justice and the reality of injustice in people's life, Justice Cameron's response was immediate and it was impassioned. You fill the gap, he said. Public interest lawyers fill that gap. Tonight we honor three amazing lawyers who have dedicated their careers to activating the promise of the law, who fill that gap every day, who fill the gap between the law's aspiration and ideals and society's troubled and unequal state. Now, it is not my job to introduce Jenny Chang Newell tonight, but I really couldn't leave the stage without saying a few words about this exceptional lawyer who I somehow have now known for 10 years. How did that happen? Because I have the best job in the universe, I just claim that right now, I actually was able to meet Jenny after she graduated and was preparing for her clerkship with Judge Berzon, who also graces us with her presence tonight, and has been one of Jenny's fiercest supporters, I think, and an amazing nominator. So Jenny was absolutely committed to working on immigrants' rights and finding a way to get a postgraduate fellowship to serve just those clients and communities. And I was fortunate that she reached out to me and that I was able to assist her along the way. I was able to work with Jenny as she found her way to the ACLU's Immigrants' Rights Project, and as she and they developed a quite remarkable project to protect garment workers in the Bay Area. Now, working with and supporting students and alumni as they prepare for their first public interest dream job on postgraduate fellowship applications allows me a certain kind of window through which to understand them. Yes? Dave, Shakti, Orion, others. And a certain kind of access to really their innermost aspirations. We get to know each other very well. And Jenny was, of course, brilliant, and she was a phenomenal writer whose applications drafts were stellar from the very first. But what struck me then, and what absolutely continues to strike me now about her, is the deep, utter commitment she has to serving clients and to locating whatever strategy it's going to take to advance their goals, be that litigation, be that something based in the community. She'll take the extra step to make sure that she gets the job done for her clients. The other thing about Jenny, though, is that she is utterly, utterly humble about her accomplishments and her talents. And you are absolutely one of my public interest heroes, so I'm delighted that we're honoring you tonight. Another of my public interest heroes is, of course, our own Professor Bill Koski, the director of our clinic's Youth and Education Law Project, and an attorney whose advocacy on behalf of children and their families and tireless efforts to improve the education system is itself, of course, worthy of celebration. Bill will introduce Jenny to you properly and present her with our Rubin Award. Thank you.
Well, good evening. I have to say this is always, always my favorite event of the entire law school academic calendar. It's an opportunity to celebrate with you the work of our students, our faculty, our alums, and renowned advocates who are working towards social justice. And it's my particular honor tonight to introduce our recipient of the coveted Miles L. Rubin Public Interest Award, Jenny Chang Newell. The Miles L. Rubin Public Interest Award has become one of the law school's most prized and exclusive awards. The Rubin Award recognizes an alum of our school whose outstanding work has advanced justice and social change in the lives of vulnerable populations on a community, national, or international level. In particular, the Rubin Award is intended to highlight concrete and sustainable approaches and solutions to a societal problem. Leave it to the Stanford Law School to have such high ambitions for our graduates, and leave it to our graduates like Jenny to exceed those ambitions. Now, the difficulty with my introducing Jenny tonight is I have to confess I didn't meet Jenny until about 2 hours ago, in the flesh, that is. I met Jenny first on paper when I was preparing these introductory remarks by reviewing her nomination materials, her bio, her accomplishments that are all over the internet. Check it out, Google her. She is all over the place. And the problem is, as I was reading this stuff, the more intimidated I became. To put it bluntly, she's a rock star. She's among the preeminent fighters for immigrants' rights in her generation in our nation. Now, I'll talk about her substantive work and victories in just a second, but what struck me in reading her nomination materials was how many times seemingly incongruous words were used in the same paragraph and sometimes the same sentence. Tenacious and sensitive, distinguished and humble, leadership and empowerment. And all of this plus, as one of her nominators put it, she's frighteningly and effortlessly smart. Now, clearly, we'd like to take credit for this at Stanford, for endowing her with all of these things that make her such a great lawyer and advocate in person, but I'm pretty confident she had a lot of them coming into our school, and I'm pretty confident she'll continue to exercise them well into the future. and to deploy them for the public good and what good she's been up to. Jenny's work has put her on the front lines, fighting to protect vulnerable communities against anti-immigrant hysteria. She's been a leader in challenging state and local anti-immigrant laws, protecting the constitutional rights of immigrants to judicial review and due process, and combating discrimination and retaliation against immigrants. For example, she's counsel in the Arizona DREAM Act Coalition versus Brewer. Now, this is a case that's brought by the ACLU and its coalition partners, challenging Arizona's decision to deny driver's licenses to young immigrant dreamers who were granted federal permission to live and work in the United States. In other words, our federal government has said that these young people are allowed to be here, to work here, to be successful and contribute to our society, but Arizona doesn't want to give them driver's licenses. Jenny and her colleagues are going to change that. She's also one of the legal architects of the federal preemption clause strategy to strike down draconian and punitive local ordinances that target immigrant populations. And she's one of ours. She's a graduate of the class of 2003, and Jenny began her career as a clerk with Judge Marsha Berzon, who I'm so glad is here tonight, of the U.S. Court of Appeals for the Ninth Circuit. Jenny was then awarded a very prestigious Skadden Fellowship to work with the ACLU Immigrants' Rights Project, and she spent the last 9 years continuing to fight that fight with the Immigrants' Rights Project. She was nominated for this award by several public interest attorneys, including Cecilia Wang and Lucas Gutentag. Cecilia is here with us tonight. They're the current and founding directors of the ACLU Immigrants' Rights Project. Two Stanford Law School alumni, Christopher Ho, Chris is here, who worked with Jenny in his capacity as the director of the National Origin, Immigration, and Language Rights Program at the Legal Aid Society Employment Law Center, and Orion Danjuma, who is a current Skadden Fellow at the ACLU Immigrants' Rights Project, working with Jenny. And of course, Judge Berzon herself was one of the nominators. Now, because I didn't know Jenny before tonight, I thought I'd share some of what those folks had to say about her. Cecilia Wang and Lucas Gutentag wrote, "While Jenny is a brilliant strategist when it comes to legal doctrines that relate to topics as technical as federal preemption and suspension clause, she never loses sight of what is most important, our clients and the larger movement for social change. She always looks for the best strategy to achieve a favorable outcome for the individual client and the communities we serve." Chris Ho says, "In her still early career, Jenny has more than earned a national reputation as a gifted legal theorist and litigator, whose successes are as numerous as they are significant. In sum, Jenny has attained a level of expertise and stature in the community of immigrants' rights advocates that is uncommon for someone of her relative youth." And this from my colleague and the director of the Immigrants' Rights Clinic here at Stanford, Jayshree Srikantaya, who is really sorry she couldn't be here tonight, but she's doing your good work on behalf of the clients that you represent in Washington, D.C. tonight. Jayshree says, "When I talk to Jenny's colleagues about her, a word that comes up a lot is superwoman. Jenny makes it all look easy, balancing life and work. She's a mom, and she's about to be a mom again. We're picking names at our table just a moment ago. Developing and litigating complex cases across the country, making key contributions to non-litigation advocacy, particularly regarding state and local laws that seek to restrict the rights and civil liberties of immigrants." And here's my favorite quote from her nominating letters. Orion gets the credit for this one. "I apologize if my language is too blunt, but Jenny is a total badass. She's at once an advocate, a teacher, and a leader. She balances the need for legal acumen with the personal leadership charisma necessary to sustain a large coalition effort." Folks, it is my great pleasure to introduce the 2013 recipient of the Miles L. Rubin Public Interest Award, Jennifer Chang Newell.
Well, thank you so much to Diane and to Bill. I hope that I can live up to some of the things that people have said. I was telling people at the table that I feel like it's all lies and hyperbole, so just keep that in mind. I feel really honored and really humbled to be sharing this evening with extraordinarily accomplished people like Pam Karlan and Roberta Kaplan. So thank you all. So probably one of the most important things that I've learned is that you have to surround yourself with people who are smarter and wiser than yourself at home, at work, and at school. And there's a long list of people who are many times smarter and wiser than me, who have generously shared their experience, their advice, their mentorship over the years. And at home, huge thanks go to my family, to my parents, for teaching me about the value of hard work and sacrifice, and about what it means to be an immigrant, and about the American dream. And to my husband, Andy, for all of his love and support, and for doing the lion's share of the work at home when my legal work is calling. And in the Stanford world, there's also many people to thank, including Diane Chin, who 10 years ago, as she said, really held my hand through the fellowship application process, and really every step of the way was so instrumental and critical in helping me start down this path. And in the years since, she's always continued to be so generous with her time and advice. And there's many professors, including Professor Carlin. I know I was in her Civ Pro, her 1L Civ Pro class, her Supreme Court term seminar, and most importantly, I was in her civil rights litigation class. And I didn't know when I took that class that I would spend the next decade suing governments for violating people's civil rights. But so I have Pam to thank for giving me that great foundation with her signature humor and brilliance in those classes. And I'd like to thank Miles and Nancy Rubin and their whole family for providing such critical support to the Stanford public interest community. And also, I'm incredibly grateful to John and Terry Levin and the Levin Center and the entire public interest community. There's also a lot of people to thank in my work life, many of whom are sitting at this table over here, including Chris Ho of the Legal Aid Society Employment Law Center. He's someone I've been looking up to since fall semester of 3L year, when I was lucky enough to intern for him. And that was where I first started thinking seriously about immigrants' rights work, where I first got a peek into what it meant to be a public interest impact litigator. And I'm just really grateful to Chris for his mentorship and his friendship over the years. And I'm also grateful to Judge Berzon, who took a chance on me and taught me so much and gave me a bird's eye view into how justice is done. In her chambers, it never mattered how poorly represented a litigant was. She was and is wholly committed to getting to the bottom of a case, to figuring out the difficult issues, and to doing right by the law and by justice, even if it means reading every word of a 1,000-page record herself. And there was no better place for me to start my legal career than in her chambers. And I've been really grateful that I've been able to continue to learn so much from her in the years since. And then there are, of course, many friends and colleagues and mentors at the ACLU who I am incredibly indebted to. And every day, honestly, I can't believe how lucky I am to be paid to do the incredibly rewarding and interesting work that I do with some of the most brilliant and strategic and compassionate lawyers in the country. The people that I work with are truly my second family. I'm thankful to Lucas Gutentag, who couldn't be here tonight, for agreeing to sponsor me as a Skadden Fellow and for letting me stick around after my fellowship was over, for letting me ask him 1,000 newbie lawyer questions and for always patiently giving such good answers. I'm grateful as well to Cecilia Wong for her friendship, first and foremost, but also for being such an incredible mentor, for all the moral support and strategic advice over the years. And I'd like to thank all of my other ACLU colleagues in San Francisco and New York, including Orion Danjuma, who's a great friend and colleague. And last, I'd just like to take a moment to talk about my clients, or our clients. Even though the impact litigation work that I do doesn't involve the same daily client interaction as many other public interest law jobs, clients are still at the heart of everything that we do. It's very difficult for most of us to understand what it's like to be an undocumented immigrant in this country, to work around the clock, to give your family a better life, but all the while living in fear and at risk of being swept up by vigilante police or by federal immigration authorities. To then have the courage to step forward and demand justice for yourself and for your community is truly extraordinary. As one of my clients, a young Arizona dreamer named Dulce Matus, has eloquently said, "Change in our communities takes courage. Many times that courage does not come from politicians, but from ordinary people standing up for what is right." Every single one of our cases has an immigrant's lived experiences behind it. Some of those stories are publicized widely in the media, like those of the amazing young dreamers who were brought to this country when they were very young, who have achieved incredible successes in their education, and who have known no other country as their home. But some of those stories are less media-friendly, like the longtime lawful permanent residents with equally deep roots in this country who, because of a criminal conviction, are now facing deportation and separation from their families. All of the immigrants we represent have one thing in common. They're fighting for a better life, for justice, and for a better America. And as their lawyers, we have a lot of work to do. Immigrants as a whole are one of the most marginalized and scapegoated groups in our country. And unlike every other group, they are by definition unable to participate directly in our political process by voting. Discrimination against immigrants by state and local governments and unconstitutional practices and procedures in the federal immigration system are all too common. And enforcing our clients' rights in court is one of the more powerful tools for change available to them. As I like to say as an ACLU lawyer, we welcome the day when our government and our justice system has progressed to the point where we're out of a job. But in the meantime, in the words of Dulce Matus, we are hungry for justice and we will continue with our efforts until we win. In closing, to the students in the room, I'd like to encourage you to join us in this fight, whether it's in your legal career or in your volunteer activities. It is incredibly challenging work, but it is also very rewarding work. Thank you.
I'm Liz McGill. I'm the Dean of the Law School. I'm so happy to see you here tonight. I want to add my congratulations to Jenny. What a wonderful recognition of your work, and it was a delight to read the nominating letters. I want to join Diane in welcoming all of the distinguished guests we have here tonight. The Levins are co-award winners, Robbie Kaplan and Pam Karlan, Judge Berzon, Chief Justice, where is the Chief Justice? There you are. The Chief Justice Kantil Sakai-Ui. We're really delighted that you're here tonight to recognize the public interest work of lawyers in the country and Stanford Law graduates. I do want to say, because as the Dean, I can sort of speak for the institution in some ways. I want to say to all the students here and all the alumni in the room, I know, that many of you have chosen a path that involves sacrifice. You've chosen it because you have a passion for it, because of your beliefs, and because of your commitments to justice. And we will continue to support you in any way that we can. And you all are my personal heroes. Our two national awardees tonight represent another kind of public interest lawyer, an important part of the scheme of how law is used to achieve social justice. We honor tonight a law professor and a partner at a prominent national law firm who joined forces with a woman named Edie Windsor to take another large step in the path towards equal citizenship under the law. I am honored tonight to introduce Pam Karlan, who is a co-recipient this year of our Outstanding National Public Service Award. Pam will then introduce her co-counsel and co-honoree, Roberta Kaplan. I think everyone in this room knows Pam, but let me tell you a little bit more about her that you might not know. She is the Kenneth and Harle Montgomery Professor of Public Interest Law and the co-director of the Stanford Supreme Court Clinic. She is a beloved teacher, mentor, and colleague to many people in this room and many over the years. She is both an amazing scholar and a leading member of the Supreme Court bar. Accomplishing a single one of these feats in a career makes a career. Achieving both at the same time is virtually unheard of. We could not be more proud of the work that Pam has done and continues to do at Stanford, most recently in support of Edie Windsor's challenge to the Defense of Marriage Act. After winning the case, Roberta said, or she actually tweeted, I'm told, that bringing Pam into the case was the best decision her team made. Jeff Fisher, the co-director of the Supreme Court Clinic, put it this way: few people in the country can match Pam's depth of substantive knowledge about civil rights, constitutional law, and the Supreme Court itself, and not a one would dare to compete with her wit. Pam is a lawyer's lawyer. She cut her teeth bringing voting rights cases for the NAACP Legal Defense Fund, and she continued litigating after she entered the academy. Her former colleague at the LDF and now Harvard Law professor Lonnie Guinier once called her one of the premier Supreme Court brief writers in the country. It's quite amazing what she and Jeff have created in the clinic, an incredibly successful way of bringing elite Supreme Court representation to clients without means, while providing an unmatched legal education at the same time. Pam's work ethic is legendary. Our offices are right across from one another, and there are very few times of the 24-hour day where you might not see Pam's light on. One of the students on Team Windsor, as they came to call it, said this: she works tirelessly. She sacrificed an entire quarter in Italy and many more than a few nights of sleep, but her attention to detail and her desire to get things right never waned. Pam is also a groundbreaking scholar. Last year, she was asked to write the annual Harvard Law Review Forward, which is an honor reserved for the most important scholars who are shaping conversation about the Supreme Court. The title of her piece, Democracy and Disdain, played off the legendary work of former law school dean John Hart Ely, upon whose antique desk Pam currently and quite fittingly does her work to further a progressive vision of constitutional values. A leading voting rights scholar, she has, with two other colleagues, literally invented the modern field of voting rights called the law of democracy. Pam is also a committed and creative teacher. A couple of weeks ago, she regaled our alumni with how she is teaching torts. Of course, she hasn't taught in a while and is teaching in an entirely new way. It's an innovative approach that takes the first years beyond appellate court opinions and puts them right in the middle of the civil justice system. I think my favorite story from that talk is that in one of the cases that the students were reading, they could click on a hyperlink of the case. It was a case involving a high-speed car chase between police and a suspect, and they could actually see the video of the high-speed car chase taken from the dashboard of the police car. This is an innovative teacher. She and Jeff, of course, review draft briefs in the clinic with students line by line, the best legal writing class you can imagine. Pam is also, near and dear to any dean's heart, an amazing institutional citizen. Year after year, she writes what may feel like hundreds of letters of recommendations, probably dozens, calls judges on behalf of her students. I think there's nothing a student of hers asks her to do that she's not willing to go the extra mile to do. Suffice it to say that every law school in the country would love to have Pam on their faculty. I'm pretty confident that everyone in this room and many more people at the law school would barricade Pam's door should any of them attempt to take her away from us. So for these efforts, and particularly for the remarkable work on the Windsor case, Pam, we recognize you and Roberta Kaplan with our National Public Service Award. Please join me.
Chief Justice Kantil Sakayuye, Judge Berzon, Dean McGill, John and Terry Levin, colleagues and friends, public interest lawyers, private practitioners, folks from the clinics, people with clinical symptoms, people who have a dream, and people who will give Sean Hannity nightmares, people who want to do justice, and people who plan to be a justice, people who represent the convicted, and people with convictions, funny people, straight men, gay women, everybody else an outlaw. Thank you, in the words of Yogi Berra, for making this day necessary. Here we are on a travel night during the World Series. It seems particularly fitting because in some ways I'm receiving the National Public Service Award here for being a late-inning defensive replacement on Team Windsor. Robbie Kaplan asked me and my colleagues in the Stanford Supreme Court Litigation Clinic, Nico Martinez, who's come back to be with us tonight, Michael Baer, who still hasn't managed to graduate, Bailey Heaps, Elizabeth Dooley, and Jeff Fisher. She asked us to play deep left field for Team Windsor to help make sure that the court didn't do the equivalent of calling the game on account of rain. Our primary contribution to Windsor was to hold on to this, law students, but it was to make sure the court didn't dismiss the case on jurisdictional grounds. Now, near the beginning of Ken Burns' documentary about baseball, the writer Shelby Foote observed that 2,000 years from now, America will be remembered especially for three things: the Constitution, jazz, and baseball. So I thought I might say a little tonight as we celebrate a great constitutional victory about what these other two elements, jazz and baseball, can shed, the light they can shed on public interest practice. Like jazz, public interest practice is about a lot more than rigid rules that are already laid down. Wynton Marsalis has given a fair amount of thought to how jazz fits into American life, and his observations bear upon public interest practice as well. The real power of jazz, he wrote, is that a group of people can come together and create art, improvised art, and they can negotiate their agendas with one another. And that negotiation is the art. Jazz means working things out musically with other people. You have to listen to other musicians and play with them even if you don't agree with what they're playing. That ability to work collaboratively, to listen to others, to adopt the notes they're playing is the hallmark of public interest practice as well, and nowhere was that more true than in United States against Windsor. And remembering who you are and what your role is critical to that process of playing new notes. The great band leader Cab Calloway observed that you hear about the Duke Ellingtons, but people sometimes forget that jazz was not only built in the minds of the great ones, but on the backs of the ordinary ones. The same is true of our Constitution. It was built not only in the minds of James Madison and Charles Sumner and Earl Warren and Thurgood Marshall and Anthony Amsterdam and Mary Bonato, but also on the backs of people like Oliver Brown and Gonzalo and Felicitas Mendez and Mildred and Richard Loving and Clarence Gideon and Rosa Parks and Edie Windsor and Thea Spire, and on the backs of the millions of ordinary Americans who did something extraordinary by keeping faith with our Constitution and by pressing forward for justice over the last 2 centuries. Well, what about baseball? There used to be this saying about the Boston Red Sox during the era of Ted Williams and Carl Yastrzemski and Jim Rice. 25 players, 25 cabs. Everybody left right after the game all on their own. There was a lot of individual talent on those teams, but they didn't win. This is a reminder that baseball is a team sport. There are about 70 plays in the average baseball game, but in the entire history of Major League Baseball, there have only been 15 unassisted triple plays. No pitcher has ever struck out more than 20 batters in a Major League game, and even the pitchers who spiked out those 20 batters, they had to have a catcher to catch the ball. So one of the things to understand is the Red Sox, a team for which I've never been able to root because they were the last team in Major League Baseball to hire an African-American player, the Red Sox started to win when the team became more than the sum of its parts. Public interest practice is the same. Robbie Kaplan and I did not win Windsor by ourselves. We were part of an amazing team of Paul Weiss lawyers, of ACLU lawyers, including 2 SLS alums, Alexis Carteron and Mariko Hirose, and Stanford Clinic members like Nico and Michael, like Elizabeth and Bailey and Jeff. And that team also included giants of the marriage equality movement like Mary Bonato. And it included our friends and our spouses who supported us during the work, especially my partner, Viola Canales, who sacrificed a trip to Italy, sacrificed dinners together, sacrificed sleep because Robbie gets up at 7 a.m. in New York and thinks I'm on New York time, sacrificed weekend baseball trips, sacrificed a normal life for months on end so I could participate. I made no sacrifices, but she did. And no one does this kind of great public interest work alone. What else? Well, baseball is a game of rules, but it's also a game about fairness. At his confirmation hearings, Chief Justice Roberts declared that judges are like umpires whose job is simply to call balls and strikes. Now, even on its own terms, this metaphor baseball undercuts this metaphor because while some of baseball's rules have the kind of precision he invokes, and we could actually get into an argument about whether the strike zone rules are like that, other baseball rules directly call on umpires to do justice. And we saw this only last week. Major League Baseball Rule 706A directs umpires to award base runners the bases they would have reached in the umpire's judgment if there had been no obstruction in the base paths. That's equity, if ever I've seen it. So too with public interest practice. We need to use the entire rule book, the Constitution, to insist on a fair playing field. So it's striking and disheartening to note that the combined payroll of the New York Yankees and the Los Angeles Dodgers this past season exceeded the annual budget of the Legal Services Corporation by $90 million. And if we fall down, we need to get up, like Alan Craig, and run as fast as we can on our injured legs to home. That's because baseball is a really, really hard game. The best hitters get on base maybe 40% of the time they come to the plate. A batting average of 300 and you'll be an all-star. The best teams lose more than one game in 3. Players who never try for that extra base do their team no service. One of my favorite baseball managers from when I was a tiny tot, Casey Stengel, once asserted that they say you can't do it, but sometimes it doesn't always work. Great players sometimes swing for the fences. They sometimes take the extra base. They sometimes try to steal home. And it's the same thing for public interest practice. We celebrate the winners, yes. But tonight I want to say that as proud as I am of being on the winning team in Windsor, I'm just as proud, even though we lost, to have been on the team in Shelby County, where I and the other members of the Stanford team represented the bipartisan leadership of the House Judiciary Committee in trying to defend the constitutionality of the Voting Rights Act. Losing brings as much honor as winning if you do it right. So let me end by pointing to my favorite piece of baseball advice. It comes from Satchel Paige. Work like you don't need the money. Love like you've never been hurt. Dance like nobody's watching. No matter how we decide to lead our lives, whether as a full-time public interest lawyer or as a lawyer for private clients with a robust pro bono practice, we need to do something where the paycheck is not the best part of the job. You've probably all heard this quotation from Paul Tsongas. No man ever said on his deathbed, "I wish I'd spent more time at the office." Paul Tsongas was wrong. People who do work that they love will feel that way. I do. I wish I had more time in the office, as well as, of course, having more time for my parents, for Viola, for my brother and my nieces, for my friends, for my pets, and for just smelling the flowers. As a matter of statistics, most of us are going to spend half our waking hours over the next 40 or 50 years in the office. And we need to make that time count for more than a fancy house or a huge pension. As for loving like you've never been hurt, well, bad things happen. We're all going to have cases we should have won that we lose. We will all see injustice triumph, in particular lawsuits, and sometimes in whole areas of the law. It hurts, believe me. But don't give up and don't become cynical. Martin Luther King Jr. said that the moral arm of the universe is long, but it bends towards justice. I try to live my life in the law as just a little weight hanging on to that arm and trying to bend it. I hope you do too, and that you'll continue to do that. Be inspired by the great lawyers and activists of the past. Like baseball, law has a long season, or as Satchel also said, let whomsoever wishes sit around recollecting, I'm looking down the line. Look down that line and keep on keeping on. And as for dancing, like nobody's watching. Well, much of the delight in your life is going to come from unexpected things and places and people. Some of you, particularly those of you who are law students here tonight, will make a life in the law enforcing statutes that haven't yet been passed, or protecting rights that haven't yet been conceived. You cannot choreograph a lifetime. Do pro bono work because it's the right thing to do, and because what you're doing will make the world better, not because someone is watching. Pick projects that promote justice, or freedom, or fairness, or peace, or dignity, or a cleaner environment, not just projects that promote you. As in baseball, the point is to connect and not to look good to the crowd. Now, those of you who know me from classes know that I like to end class with a poem. Here's a poem that's inspired my life in the law since before law school. It perfectly captures what made Windsor such a special case for me. United States against Windsor was a case about love. Not just the love that Edie Windsor had for Thea Spire and Thea had for Edie. Not just the love that gay couples throughout the United States share. Not just the love that I have for the Constitution, but about the love our team developed for one another. The poem is the end of Alfred Tennyson's Ulysses. Come, my friends, 'tis not too late to seek a newer world. Push off, and sitting well in order, smite the sounding furrows. For my purpose holds to sail beyond the sunset and the baths of all the western stars until I die. It may be that the gulfs will wash us down. It may be we shall touch the happy isles and see the great Achilles whom we knew. Though much is taken, much abides. And though we are not now that strength which in old days moved earth and heaven, that which we are, we are. One equal temper of heroic hearts, made weak by time and fate, but strong in will to strive, to seek, to find, and not to yield. In that equal temper of heroic hearts, no heart beats more strongly than Robbie Kaplan's. Every day, as Liz says, I sit down to work behind a desk that used to be John Hart Ely's. John famously began Democracy and Distrust, one of the most influential works in American constitutional law, with the following observation: you don't need many heroes if you choose carefully. I can't claim that I chose carefully. I lucked into working with Robbie Kaplan. But since then, I've been lucky to have her as one of my heroes. We celebrate July 4th as Independence Day, the day in some sense when we began to be Americans, free people rather than colonists. I say began rather than became for an obvious reason. As another one of my heroes in the law, the great Texas Congresswoman Barbara Jordan explained, we the people. It is a very eloquent beginning. But when that document was completed on the 17th of September in 1787, I was not included in that we the people. I felt somehow for many years that George Washington and Alexander Hamilton just left me out by mistake. But through the process of amendment, interpretation, and court decision, I have finally been included in we the people. For many years, LGBT people were excluded from some of the most central institutions we the people have, from public service, from the armed forces, and from marriage. Robbie Kaplan, through her work on the New York marriage equality case, Hernandez against Robles, and her work on the DOMA case, United States against Windsor, has expanded our Constitution's recognition of gay people as part of that we. And she did that as much through the case she lost as through the case she won. Anyway, about Independence Day. On July 4th, 2012, I received a short email that changed my life. And I can read you the whole thing. Professor Carlin, I am a partner at Paul Weiss and counsel to Edith Windsor in the estate tax DOMA challenge pending in the Second Circuit. Decision by SDNY Judge Barbara Jones on rational basis grounds was issued last month. I was wondering if you had any time to discuss some issues with us. I very much apologize for emailing you on the July 4th holiday. Unfortunately, the issues are somewhat time sensitive. Thanks so much in advance for your time. Any help you can provide us will be graciously appreciated. Best regards, Robbie Kaplan. Robbie always says when she talks about United States against Windsor that it took her about a second and a half after meeting Edie Windsor to agree to represent her. It took me about the same time to sign on to Team Windsor. So why is Robbie one of my heroes? It's not primarily because she won Windsor. The truth is, Robbie isn't the only lawyer who could have won that case. Sure, she did a great job with the briefing, her countless line edits done by hand, because when she started practice, female partners at Paul Weiss told her, as a woman, never show that you can type. She delivered a splendid oral argument. But you know what? History, social forces, a client with a compelling story, a court with 5 justices receptive to the idea that gay people deserve equal dignity and respect, all of those factors would have been there for other skilled lawyers as well. And it was luck, or at least not something within Robbie's direct control, that prompted the Supreme Court to take Edie Windsor's case instead of one of 3 other DOMA challenges that were pending at the same time. What makes Robbie my hero is how she won Windsor, not that she won it. Robbie was an inspiring and generous leader of a team of lawyers. She got us all to do our best work. No one ever stormed out of a room, even under savage time pressure. Just as important, she was, like Jenny was talking about a moment ago, client-centered. Those of you who are students in the law school who came to the lunch talk yesterday heard Michael Baer talking about the Post-it that Robbie kept on her computer throughout the case that said, "It's all about Edie, stupid." She was simultaneously fiercely protective of and totally respectful to the brave, passionate, determined woman who was our client. The legal scholar Charles Freed wrote a famous book entitled The Lawyer as Friend. Robbie lived that motto. Just as important, Robbie was fearless. Now, Robbie is a deeply religious person, so she's probably going to recognize this saying of Reb Nachman of Breslov's that many of us remember as a song from Temple Youth Group. Kol ha'olam kolo, gesher tzer ma'od, v'ha'ikar lo lefad kalal. For those of you who didn't have to go to Temple Youth Group, you should thank God for that. No. For those of you who didn't have to go to Temple Youth Group, the translation of this is, all the world is a very narrow bridge, and the most important thing is not to fear at all. That fearlessness is why Robbie is my hero. In a world where far too many lawyers are cool or diffident, she is hot. Way hot. In a world where female lawyers often shrink from confrontation, she is strong, way strong. In the face of contradictory advice, she listened, she took what was best from each person's suggestions, and she kept her eye on the prize. She did not back down. She did not pretend. In an environment where some folks were ashamed, urging her to soft pedal our client's sexual orientation, and other people were shameless, trying to hog all the credit for themselves, she stayed herself. Now, many of you know that one of my other favorite pieces of advice comes from the great American legal philosopher Yogi Berra. He says, when you come to a fork in the road, take it. Robbie has done exactly that. She is an amazing gay rights litigator, but she's also a first-tier commercial litigator. As a partner in Paul Weiss's New York office, she represents established financial institutions like J.P. Morgan Chase. She represents governments in high-stakes litigation, serving as counsel to California in the PG&E bankruptcy. And she's recently become the go-to strategist for the sharing economy, representing upstarts like Halo and Airbnb. And she says she would like all of you to sign up for Airbnb so she can come and stay with you. She's a devoted wife to her spouse, Rachel Levin, and an amazing mother to her son, Jacob. She's a generous mentor to younger lawyers, and she's a wonderful friend. She lives the good life in both senses of the world. So it's a real pleasure to turn the lectern over to Robbie Kaplan, my friend, my co-counsel, my hero.
excuse me. Tonight is both the best of times and the worst of times. It's the best of times because I'm here in beautiful Palo Alto at this terrific law school, and I even got to have breakfast this morning with Pam Karlan. I am so incredibly honored and grateful to be here tonight. But it is also the worst of times because I actually have to speak at the same podium, in the same place, but after Pam Karlan, something that no lawyer in the United States of America ever wants to do. There is one thing that I know for sure in life, and that is that no human being knows what life has in store for them, either personally or professionally. Our client, Edie Windsor, surely didn't. As a young middle-class woman growing up in Philadelphia after World War II, she had absolutely no idea that one day she would become the out lesbian who just happened to sue the United States of America. The same, of course, is true for me. As a closeted lesbian growing up in Cleveland, Ohio, if you had told me that one day, as an out litigation partner at Paul Weiss, I would marry a woman, have a child, and then win a landmark civil rights case before the United States Supreme Court, I would have told you that you were certifiably insane. It's worth noting that I did not build my career as a Supreme Court practitioner. I did not clerk for a Supreme Court justice. I did not work in the Solicitor General's office. Indeed, the oral argument in Windsor last March was my first appearance ever before the United States Supreme Court. Instead, I grew up as a lawyer in the Paul Weiss litigation department, where most of the cases that I handled were for corporations, primarily in the trial courts, both federal and state. One of the first lessons that any good trial lawyer learns is that facts matter. They really matter a lot. In fact, any good litigator knows that facts can be very, very stubborn things, and that is unwise, if not foolish, to bring or defend any case without paying very, very close attention to the facts before, during, and after trial. In our case, this was very significant. It was significant not only because of who Edie Windsor is, but because in contrast to many of the LGBT rights cases that had been brought in the past, our case involved only one plaintiff, or two plaintiffs, I really should say, Edie and her late spouse, the Aspire. I think that what often got lost unwittingly in prior gay civil rights cases with multiple plaintiffs is the stories of the plaintiffs themselves. After all, it is hard for a judge or jury to focus on several plaintiff couples at the same time, but it is much easier to focus on only one. And unfortunately, when the facts fade into the background, a gay civil rights case can look more like a debate between pundits on Fox News and MSNBC than a case about real people and their lives. From the very first moment I met Edie, I believe that the best way to convey the harm and indignity that DOMA caused to so many gay people throughout this country for so long was to tell the story of how it harmed only two people, Edie Windsor and her late spouse, the Aspire. In order to do that, we needed to tell the story of Edie and Thea's lives as the great love story that it was. We used the facts to turn our complaint into a kind of mini biography, what old-style New York practitioners would call a speaking complaint. And perhaps most importantly, we told the story not only of what it's like for gay people today, or yesterday, or 5 years ago, but what it was like for gay men and lesbians in the 1950s, the 1960s, and the 1970s. Like the fact, for example, that when Edie was called in by the FBI for an interview when she was working for the Atomic Energy Commission to support herself in grad school, she rightfully feared that if the FBI were to ask her if she were a lesbian, she would lose not only her job, but her career as well, since of course at that point in time it was completely illegal for anyone who was gay to have any employment relationship whatsoever with the federal government. Or the fact that when Thea first asked Edie to marry her in 1967, think about it, 1967, 2 years before Stonewall. Or the fact that when she did so, Thea did it with a circular diamond brooch rather than a ring, because if Edie were to wear a ring at her job at IBM, it would expose her as a lesbian, and they would ask her who the lucky guy was. Or the fact that when Thea was diagnosed with a particularly virulent form of MS, Edie has said that the diagnosis happened to both of them and made sure that as little in their lives changed as possible. Facts like these speak for themselves. They tell a story not only of the lives of two women, but of the lives of so many gay Americans of the very generation that people in our country, it's so easy to forget. And that is crucial because it's just too easy today not to understand what it was like for gay people simply to go about their lives with dignity only years ago. In the context of the Supreme Court, this was important for another reason. After all, several of the Supreme Court justices themselves are contemporaries of Edie and Thea. Justice Ginsburg, for example, is 80. Justice Breyer is 75. And Justice Kennedy, who of course wrote the majority opinion in Windsor, is 77. One of Justice Kennedy's oldest friends was a man by the name of Gordon Shaber. I hope I'm pronouncing that right, Pam, am I? Who was the dean of Sacramento's McGeorge School of Law. Time magazine has reported that Justice Kennedy was aware that Dean Shaber, who died in 1997, was secretly gay. Larry Levin, another professor at the law school who himself is gay and who knows Justice Kennedy, has said that he doubts that Justice Kennedy and Dean Shaber ever discussed that fact. Why? Because as Professor Levin explained, with people of that generation, no one talked about it. Again, that was precisely our point. People of that generation didn't talk about it because of the homophobia that was so prevalent and the shame that simply attached simply to the fact of being gay. I'm thrilled to be able to say that our strategy worked. The Supreme Court clearly appreciated the story that we were trying to tell. Here is how Justice Ginsburg recently recounted Edie and Thea's story. There were two people who lived together in a grand partnership, and one of them was dying and wanted to have the official blessings of government on this union, so they married. And then one partner died, and the other gets something like a $363,000 estate tax bill from the government. She would have no bill at all. If her marriage were recognized, she'd get the deduction. So that was the DOMA case. I have to admit that when I first heard this statement from Justice Ginsburg, I almost fell over in my chair. After all, Edie and Thea's grand partnership, again, was precisely what our case was all about. Given today's fast-paced world of Twitter, of Facebook, of Politico, of Ted Cruz, of the Tea Party, it's all too easy to become cynical, to assume that it's all one big inside game and that cases never get decided on the merits, but for other less principled reasons. I'd like to offer U.S. v. Windsor as an antidote to that kind of cynicism. The decision in Windsor affirms the basic principle that discrimination against gay people solely because they are gay violates the Constitution. You may have heard that Justice Kennedy uses the word dignity 10 times, if I'm counting right, in his 26-page opinion for the court in Windsor. While we all know what dignity means, since I'm a bit obsessive and compulsive, I thought I'd look it up just to be sure. According to the Oxford English Dictionary, the word dignity means the state or quality of being worthy of honor or respect. Sometimes it's the simplest and most obvious things that say the most. The state or quality of being worthy of honor or respect is exactly what the Windsor case was all about. I need to close by expressing in clear and unambiguous terms my eternal gratitude to Pam Karlan and this law school. I've made at least 3 very smart decisions in my life. The first was getting married to my wife, Rachel Levine, in 2005. The second was taking Edie Windsor on as a client in 2009. And the third was having the chutzpah to send that email to Pam Karlan out of the blue on July 4, 2012. I'm going to tell a story about the kind of person that Pam Karlan is, although most of you probably already know that. One of the issues in the case, once the Supreme Court took the case, was who was going to argue the case. And as you can imagine, there was a lot of pressure and a lot of discussion about maybe it wasn't such a great idea to have someone arguing their first time in a case of this significance. And there was one person I went to make that decision, and that person was Pam Karlan, knowing that if I didn't argue the case would be argued by Pam Karlan. And I asked Pam what she thought, and Pam told me in a way, something that I will never forget as long as I live, that I should argue this case, again, knowing that in giving me that answer, she wouldn't be arguing it. I have to say, I don't think that there are many lawyers or many human beings on this planet that would have handled that conversation with the grace, the generosity, and the kindness of Pam Karlan. It is surely no exaggeration to say, despite what you heard her say, that we never would have won this case without her. Thank you so much.
Thank you, Jenny, Pam, Roberta, so much for sharing your evening with us and allowing us to really honor the important and incredible people that you are, not just the work that you've done. So thanks, everybody, for coming. That's the end of the program. Please stick around and talk for a little bit, but thanks so much for coming.